we are going to be picking up on a question that came in from a listener around airlines cancelling an entire trip if a passenger fails to show up for just one of the legs. And if you have had experience of this and you would like to share it with us, do remember you can call in on 02144600567 or send a WhatsApp to 072-567-1567. Always good to have you with us, Wendy.
Thanks, Pippa. Good to be here.
Now, at the end of last week's show, we shared an email from Tim, who was outraged. British Airways had cancelled several legs of a multi-leg journey without his knowledge. And you explained briefly at the time that what Tim had encountered was not a BA-specific issue, but in fact quite standard practice in the industry. Won't you start there? Just remind us.
Yes, of course. So it's an airline policy which I think is fair to say few people outside of the aviation industry know about it. Those that have experienced it, and I'm one of them, you certainly know about it and don't forget about it and tell people. So how it works is if you miss one of the legs of your international flight itinerary for whatever reason, and you don't tell the airline, and even in some cases if you do tell them, they still, because it's an auto cancel, right?
Yeah.
And then you say, well, actually, please don't cancel. I still intend taking those legs. Then some of them make you pay a no-show fee or whatever to reinstate. But anyway, if you do nothing, then you found out usually quite late that your ongoing flights have been cancelled. So what we're talking about here is a unilateral decision on behalf of an airline to cancel your ongoing seats, the rest of your journey that you have pre-booked and prepaid. Let's not forget, yes. Unilateral in that they don't even have to tell you they've done it when they don't tell you. And you are then left having to scramble, you or your travel agent, and I would say this is certainly one of those scenarios where it really does pay to go through a travel agent, because I hadn't. In my case, it was a Virgin Atlantic case. I'll never forget it. You're then left scrambling, to get alternative tickets, usually at far higher price because it's last minute. And the airline, of course, will inevitably, I would say, we're long past COVID, sell that seat or those seats if you're traveling with a party, and at a higher price too, let alone recoup
To
their
somebody
money.
else. So they actually make a profit off it.
In most cases, I would say, yeah, for sure.
Okay, so standard practice around the world across all airlines, but is it legal is the question we want to probe a little bit more deeply today. So let's just remind everybody of Tim's particular story. Tim told us in his mail he is a local businessman. His kids are in the UK and he had booked return tickets for them to join in Cape Town for their holidays. So they were booked to fly from London to Joburg and then would catch a connecting flight on what must have been a code sharing deal with Airlink, because it was booked on the BA site that they would catch an Airlink flight on from Joburg to Cape Town. And Tim made and paid for those bookings, and then only afterwards did he look again and realize, hang on a second, these children have a very long layover in Johannesburg, and he wasn't too comfortable at the thought of them being on their own in the airport for a very extended period. So he first tried to move them onto an earlier connecting flight, but neither BA nor Airlink could adjust the booking. So he then decided, okay, I'll take the financial hit and I will buy them a different flight for the Joburg Cape Town leg, which he did on a different airline, a low-cost airline off book on Fly Safair. That flight leaves Joburg much earlier and they wouldn't have as much time spent at the airport. And that is exactly what he did.
He was prepared to sacrifice that
leg of the trip.
The domestic leg.
Yeah, for the sake of buying a different ticket that would get them there sooner and not have them exposed in the airport.
That's what he thought he was in for.
That's what he thought. Yeah. So all went fine at first. They made it from London to Joburg. They safely caught their Safair flight to Cape Town. They had a great holiday. But it was when Tim went online to try and check him in for the flights home that they realized things had not gone according to plan. And Tim is with us on the line to take up the story. Tim, it's great to have you with us this afternoon. Thanks for sharing this. And I'm really sorry that you had this experience, but I appreciate your sharing it so that others can learn from it.
Hi, Pippa. Hi, Wendy.
Hi, Tim.
So, Tim, when did you first realize that something had gone awry with the return flight itinerary?
So they stayed here for 10 days, and it was only when I went online 24 hours before the return flight back to the UK, I went on to manage my booking on the BA website to check them in, and I was given a message that all flights on this booking have been flown.
Oh.
At which point I got in touch with their call center, international call center, and I was told that the booking's being cancelled because they were deemed a no-show because they didn't turn up for the Airlink flight in Joburg, and all ongoing flights, so the direct flight back from Cape Town to London was also cancelled, and that those flights were not refundable.
As I said last week, the logic flaw in that assumption is that they didn't they weren't a total no-show. So they obviously would have, because they flew them here, known that those children landed in Johannesburg. So in cancelling the return flights, how were they, I mean, without even a call to explore what happened, they just cancelled.
They just unilaterally.
I think I don't think the logic flaw is actually more of a case of, as a travel agent told us, just an automatic cancellation without applying any human rationale to the situation.
Yeah. But Tim, at no point did you get any warning of this. You only found it because you decided that you would log in online, check in online a day before.
Yeah, so if I hadn't done that, and if I'd just turned up with them at the airport before their flight, they would have been told that they're not on the plane. So it bought me 24 hours to try and find another solution. But in trying to rebook, I tried to rebook the BA flight when I was told it's not refundable, and I was told it was going to cost 17,000 rand per child, and there are two, so that's 34,000 rand for a one-way flight. And they couldn't fly them out on that day. It was 2 days later. So whilst I was on the chat with the agent, I went online. I managed to book Lufthansa flights for 7,000 rand per child. So it's just a rip-off from start to finish.
So BA says no refund for either the local leg or the international leg. You've out of pocket another 14,000 to get them home via Lufthansa, but at least you didn't have the indignity of paying British Airways 34,000 rand for the pleasure of taking the trip you already paid them for. So the big question is Wendy, around fairness and legality. Is that fair? Certainly not. I think most people would agree. Is it legal though?
Well, this in terms of South Africans and our Consumer Protection Act, we're going to be joined in a bit by Gerard van der Merwe of Trudy Brookman Attorneys, who at my behest very kindly did a deep dive into that for us, and he'll share in a bit. But I did some research on this, obviously, and interestingly, the information I could find, there was a big outcry in 2019. There was a case similar to this, and that made it into the media, and a lot of the stakeholders in the industry were canvassed. And I couldn't find anything more up to date, but it claimed a consumer watchdog, which I'm sure Tim knows about. They call this no-show clause a rip-off, and they've called for airlines to get rid of it as an unfair term that leaves passengers out of pocket, and the airline able to resell those seats rather for a profit, as we said, which argues that this breaches their Consumer Rights Act, which is very similar to our Consumer Protection Act, and the Unfair Terms in Consumer Contracts Directive, creating which called a significant imbalance between the airline, which makes money from the clause, and the passenger, which loses money from it. It's totally unreasonable for an airline to cancel a passenger's return flight, often without warning, simply because they've missed the first leg of their journey, said Caroline Normand, who was Which's director of advocacy at the time and until recently. She said airlines have been able to cash in with this tactic for far too long, leaving people miserable, stranded, and hundreds if not thousands of pounds out of pocket.
Okay, so that was an international response. Wendy, did you come across any local commentary on this practice?
No, only, and I mean, I've sourced it certainly when that happened to me. Then it was about 2012 on a trip to Canada via London, and obviously came back and wrote about my personal experience. It wasn't even that I'd missed it. Virgin Atlantic had an international flight plan crash for all flights landing in Heathrow. And so we left instead of 8 in the evening, we left at 2 in the following morning, and we missed our flight to Vancouver, and we had to overnight. And what Virgin didn't do was correctly code it or whatever. So we were effectively, my parents and I, we were down as no-shows because we missed that original
Through no
flight.
fault of your own.
Exactly.
Yeah.
Their direct fault. And then when I tried to check in, exactly the same thing. My parents had had gone to the States with my sister, and I was flying home alone, and I spent the last day of my precious holiday with my cousins trying to get back home because my flight had been cancelled. So I understand this. So at the time I came home and I wrote this outrage piece. But as we'll hear from Gerrit, it might be, and in the UK it's not compliant with specific consumer protection laws, but there hasn't been a court case where it's been found directly not applicable, shall I say, that the airlines have been found to be acting unlawfully, and there certainly hasn't been a directive internationally, because these involve all airlines internationally, right? There hasn't been a directive that bans it. It would have to be in several countries. Obviously, there's no global law, but the bottom line is it continues. I think sooner or later it will come to an end, but for now, this is the reality, and the main reason I want to do it is that people know and spare themselves
what Tim has just gone through.
Exactly.
Yeah. So just to wrap up with Tim, I mean, your kids made it safely home in the end. You out of pocket the extra 14,000 Rand you had to pay Lufthansa to get them home. Have you made any attempt to demand a refund or ask for a refund from BA beyond those initial engagements?
So I've gone. So I struggled with the call center. I asked to be escalated to a manager, and they said they'd explored that. They'd explored all their resources, was their response, which I didn't really understand. So no, I to be honest, I haven't. There's no obvious route. Wendy sent me an email just now, actually, which had some kind of refund policy, which I'll explore later.
Okay, well, give it a try, Tim, and please do let us know if it works for you. I'm really sorry this happened to you, but thank you again for being willing to share what happened to you so that others can learn from the experience that if you have missed, for whatever reason, your fault, the airline's fault, completely unforeseen circumstances, a storm or a lightning strike, it doesn't matter. If you missed one leg of a multi-leg journey, be aware of the fact that the airline policy is most likely going to automatically deem you a no-show and cancel everything else associated with that trip. So you need to very proactively make contact with the airline to let them know if you're still planning to use the rest of the legs. Now, Wendy, you did get some input from the Civil Aviation Authority on this.
No, this was actually my research done internationally, so that's the Civil Aviation Authority in the UK, and they released a report in 2019 to say that this policy of automatically cancelling flights was disproportionate and that these clauses failed to meet the level of fairness and transparency, blah, blah, blah. But it's still the status quo. So obviously the airlines are wielding a lot of power here. And just to say, the reason it's thought, I mean, I've spent some time on aviation groups online, and the travel industry or the aviation industry all think it's perfectly normal and actually defend it to some extent, because it arose out of people. You know, sometimes you can. It pays you to. It's cheaper to buy a whole continuous journey than individual flights or something like that. So people are playing the system by booking the full one and not taking that leg and then getting a cheaper one, something like that. It's quite complicated, but frequent flyers obviously found a way to play the system, and this is the airline industry's way of circumventing that. People booking with the intention to cancel because there's a cheaper way to then buy another leg or something like that.
What irritates me is if you've paid for the ticket in advance, there's no loss to them. Even if nobody is sitting on that seat when the plane departs, it's been paid for, so there is no loss to them. Kirst writing in on the WhatsApp line to say this has always been the way with through fare tickets. I have learnt the hard way years ago as well. Wendy, you had an interesting engagement with a local travel agent after we raised this last week.
Yes, Nikki, and she was so eloquent and delightful when I spoke to her on the phone, but she couldn't be convinced to come on air. For some people, it's just a daunting prospect, and we understand that. So she said she's 30 years in the game. You know, she remembers, as I do, you know, the paper tickets. And incidentally, she says in those days, before everything was computerized, all you did if this happened was tear out the coupon for that particular leg that you didn't take, and no one was any the wiser, and off you went. There was none of this auto cancelling or anything like that. But she said all the systems, and she said as far as she's aware, and she deals with most of the airlines, they all do it. The systems are set up to cancel ongoing legs the moment a flight is taken out of sequence. That's the key here, out of sequence. And the minute a sector is no-showed, that's what they call it in the industry. When a sector is no-showed, a ticket has to be used in sequence, and the minute it's not, the onward return flight gets auto-cancelled. She said, we travel agents have days of stress when passengers miss a flight, and we spend hours trying to get them rerouted and helped so that they don't lose the rest of their bookings. She says some airlines will reinstate the rest of the tickets in the journey, but some will charge a fee for that, $50, which is not inconsiderable to us,
given the exchange rate. And
some impose a no-show fee of $50 and a cancellation fee of $50. So now we're talking $100. So yeah, the unfairness factor is huge. And Nikki did say Tim probably won't get his money back from BA. They will say it's the rules, but he certainly should try, because I found online, yes, you can apply. And he's got nothing to lose at this stage.
Okay. So we're going to pause there, take a short break, and then listen to the news. And when we come back from the news, we're going to delve into the question of legality, because certainly I think most people would agree it's very unfair to the consumer.
It's what the Act calls unconscionable, actually.
Okay. But is it illegal? That is the question. We're going to put that to a consumer attorney. A couple of listener voice notes coming through. Let's take a listen to those.
Good day, Wendy and Pippa. Relating to the cancellation of the airline tickets without any refund, what about the portion that's paid towards airport taxes, where the consumer wasn't able to make use of those things? Is there any refund that can come his way? Thank you.
Hi, Wendy. This is Quentin. I'm a tour operator and I run safaris throughout Africa. Now, we had a situation with what was termed as a no-show, but there had been a technical issue with an aircraft from Kasane, a Airlink aircraft from Kasane to OR Tambo, which meant that I and my guests missed the ongoing flights. Me only to Cape Town, but them to London, one half of them, and the other half going to Sydney. And we spent 3.5 hours on the phone trying to reach BA call center as well as Qantas call center, and because it was a Sunday, there was just no response. So it was recorded as a no-show, and they had to repurchase tickets again. And when they tried to argue the case with both airlines, they were basically turned down flat. Now, what happens in the case legally, where you have made every effort, and we had recorded the telephone calls, where you get through to the call center and you're on the recorded message only. I would like to hear what, from a legal point of view, what our rights are there.
Okay, I'm so sorry that happened to you, Quentin, and we'll dive into the legal conversation now. But before we do, Riaz's point about the airport taxes is very interesting.
Yeah, it is an interesting one. I haven't pondered that, to be honest. I suppose it would depend. When they're paid. Are they paid? Do the airlines pay them directly when the passenger pays, or only once they've flown? I don't know, but either way, I think you would have a hell of a battle on your hands to try and get that money back.
Yeah. Okay, so
not that that's fair either.
Yeah, let's try and answer the question from a legal perspective. And Wendy, as she's indicated, really feels in her gut that this is not treating customers fairly is one of the phrases that crops up in the Consumer Protection Act very, very frequently. So we're calling on Gerard van der Merwe of local Trudy Brookman attorneys, local consumer law specialists, to talk about the legalities of this. And Gerard is with us on the line now. Gerard, thank you so much for doing a bit of a deep dive into the subject for us this afternoon. Before we dive into the legal details, had you ever encountered cases like this? Have you heard of this no-show policy before Wendy reached out to you?
Hi, Wendy. Yes, I must say, when Wendy sent me an email and I responded to it, I told her, to my mind, I thought it was common knowledge, but simply because I know friends that are travel agents, and I've heard about their battles, like the previous travel agents have indicated, and that's the only reason that I knew about it. It's never physically happened to me, but I was aware of it, and that it's standard practice, and the fact that it's standard practice obviously does not necessarily make it legal at the end of the day.
Yeah,
That's the big question.
exactly. So I know the law is complicated, and you've done a very deep dive for us. Thank you very much into exactly which sections of the CPA would make such a practice not legal, or that which practices would be not compliant with the Act. Would you mind, and I know it's difficult for lawyers because you are trained to be comprehensive about these things, but if you could just quickly run through the sections that apply here, that would be very helpful.
Certainly, I'll keep it crisp and succinct. I think to start off with is just to say that the Consumer Protection Act would apply because of the fact that there's local legs involved, and the passengers are being flown to South Africa. So that's just to start off with. The South African CPA is definitely applicable to the services being provided by the airline. Now, as you mentioned and Pippa mentioned as well, a running motive through the CPA is that suppliers may not act in a way that's unconscionable, which is unfair, unreasonable, or unjust to consumers, and the terms and conditions in the agreements should also not be any of those things. So in my opinion, these types of terms and conditions are definitely unfair, unreasonable, and unjust because they are excessively one-sided, they're inequitable, and it also constitutes a risk that a normal, ordinarily alert and reasonable consumer would not necessarily have known about. So it's not brought to the attention of the consumer as far as sections 48 and 49 of the Consumer Protection Act is concerned. That specifically says that you need to bring this to the attention of the consumer in a way that's conspicuous, which is in plain language. You must give them sufficient opportunity to read or to hear if it's read out telephonically. These specific clauses that limit their rights, they must have an opportunity to consider it, to comprehend it, and then assent to it, and most importantly, before they make payment or before it's expected of them to pay any consideration. But in practice, that simply doesn't happen. You pay and you're referred to the website T's and C's. You go there. There's nothing that stands out. So it's really a case of consumers don't know, and the airlines make no effort whatsoever to actually inform them of this. And then the CPA also says that any standard terms and conditions or consumer agreement must be interpreted in favor of the consumer and to promote the spirit and the purpose of the Consumer Protection Act. And a consumer's rights may also only be limited to an extent where, like I said before, a reasonable consumer would be expected to be alert to the fact that is actually part of the agreement.
Okay. So in this case, on the website, for example, there would have been this line somewhere in the terms and conditions: British Airways will automatically cancel any remaining unused flights if you don't show up for a flight without giving advance notice. So that would be contrary to what the reasonable average person would think would be a term and condition, right?
Exactly. One would expect a supplier or an airline to actually go through the trouble of informing consumers, because we know for a fact consumers rarely go onto the website and read all the terms and conditions, because a lot of it's in legalese. They know they have no bargaining power, so what's the use of reading it if I can't convince the supplier to change it?
Yeah.
But that doesn't detract from the fact that it shouldn't be unreasonable or unfair or limit the consumer's rights in any way, or that it should be brought to their attention at least. And then as far as the cancelling of the remaining legs are concerned, I heard the airport tax question, and I also haven't thought that part through. But in terms of Section 65, I would say that the prepayment or the payment for the flights that haven't been used constitutes a prepayment for purposes of the CPA. So the airline is not allowed to keep it and once it cancels out the flights, because they don't render a service in terms of the remaining flights. So that should be refunded to the consumer. And in terms of Section 52, it also specifically mandates the court to order that where a term is unfair, unreasonable, or unjust, or where it wasn't brought to the attention of the consumer, to order the supplier to refund the consumer and, importantly, to reimburse them for any losses they had to incur in all these instances having to book alternative flights.
At very last-minute expensive
Yeah.
rates.
Exactly.
Can I just share? I mean, Andrew's just messaged us from Cape Town asking, surely, why isn't it considered fraudulent practice to sell the same seat more than once? The seat's been bought and paid for by that passenger. Surely they now own the seat in the same way as applies to timeshare, and that space can't be sold to another person at the same time. Do you agree with Andrew's comment, Gerard?
Yes, that would basically tie in with the provisions regarding overbooking and cancellations as far as that's concerned.
And interestingly, sorry to butt in, Gerard, the Consumer Protection Act, I heard on very good authority that a few of the legislators had been bumped off flat due to the practice of overbooking, which is another international practice. And the CPA actually carries a section which says if that happens, they've got the passenger has a few options. They can accept the next available flight that, if it suits them, or they must be refunded and compensated any direct costs related to it, like I had to pay for a taxi because my lift wasn't available anymore, or whatever. And I've urged a lot of
accommodation.
Yes, whatever the case may be. But they didn't think of this one. Unfortunately, that would have helped a lot. But
no, definitely that would be Section 47 of the CPA.
But the point is, as you've explained, there are many parts of the CPA which such a policy would contravene, and in such cases, any term and conditions in a service provider's contract is then null and void if they don't comply to the legislation in this country and they're operating in this country, right?
That's correct. That's what the aim of, or what the purpose of the CPA provisions in this regard is. It simply states that those provisions should be read as if they aren't in the agreement.
And then we sit with lovely protection.
Airline,
We've been wronged, but now to get justice, if they say no, it's our policy, go away, then you've got to take it to either a consumer protection agency or hire an attorney. And, it's a long, arduous process. But it would be lovely if somebody would do that and create a precedent around this. I just don't understand why that hasn't happened. Because it's a lot of money. In Tim's case, he paid 34,000 rand extra to get his children.
He paid 17 in the end, I think, when he went, and 14 through Lufthansa. But BA expected him to pay 34.
Right.
It's still a lot of money.
They expected him, my bad.
Yeah.
They expected him to pay 34, and he ended up going elsewhere and getting it less than half. Yeah.
Gerard, thank you so much for explaining the legalities for us. We really appreciate your contribution this afternoon.
You're welcome, Pippa. Enjoy your day.
You
Thanks,
too.
Gerard.
Keep well. Gerard van der Merwe of Trudy Brookman Attorneys explaining which sections of the CPA that particular favour would seem to fall foul of. And Wendy, as you say,
I'm sure it will happen.
The
One
landscape is prime for someone to take on the case. Debbie making an interesting point on WhatsApp. She's saying, would travel insurance cover this kind of incident? So if you had taken out travel insurance on your trip.
It is an interesting question. It's been a while since I've waded through one of those policy documents. I know they cover all sorts of things going wrong with flights, cancellations, etc. Definitely something for me to look into, yes.
Okay.
Given the amount of money involved, there's probably a few exclusions there, but yeah.
Worth investigating. I do like Denise's description. She says it's like eating half your ice cream and then the store takes it back to resell the other half. It doesn't seem fair to me. You and me neither, Debbie, Denise and many others. So again, I think a conversation that will no doubt be continued at a later date when hopefully somebody takes it upon themselves who has the resources and the time and the energy to actually take on an airline with a legal challenge to this practice and say, actually, you didn't have the right to cancel that flight. You certainly didn't have the right to keep my money when you did. And let's see you in court. Look forward to the follow-up conversation on the day that happens. Steve, good afternoon. Thanks for ringing through. I believe it's an issue around some shoes.
Yes, thank you for taking my call.
Sure.
I bought a new pair of Crocs at the waterfront this morning, and I went into the shop, looked at the shoes, and the pair of Crocs was advertised at 899 Rand. When I went to the cashier to pay for the Crocs, the cashier said, sorry, they had mispriced them on the label. And when he scanned the label, he said, no, they're actually 1,500 Rand, which I ended up paying for them. But I was just wondering, I know Pick and Pay has got this thing, you pay the price marked. I was just wondering, have you got any recourse with them?
Yes, you do, in my opinion. It certainly works this way, and we say it often on air with a supermarket, and some supermarkets actually will go beyond what's legally required and compensate people if the price is wrong, that being Woolies and Pick and Pay. So I took advice from the Consumer Goods and Services Ombudsman many years ago on this. So their feeling was if you got to the till, say in a supermarket, and I don't see how a Crocs store would be any different, and what scans is different from the price advertised on the product or at the shelf, then you are entitled to say, thank you very much, I will have that price. Unless it's a really obvious mistake, then it was, marked at 8 Rand or something, and then you would be considered to be a consumer snatching at a bargain, and they would be entitled to say, sorry, we're not honouring it. But in this case, it's just a case of sort of sloppy merchandising, and you were entitled to those Crocs at $8.99. I'm a Crocs wearer myself. Pippa's pulling a face.
I won't judge either of you.
Have been wearing for 25 years or more. So I know the prices, and it's not unusual to buy a pair of Crocs for $8.99. So I don't think they could say that was an obvious mistake. So I would say go back to the store. You can quote us and say you would appreciate a refund of the difference. Thank you.
They should honour the price that was on the item on the shelf.
Yes.
As advertised. Steve, you think you might give it a try?
I will try, definitely. I don't know if I'll get anywhere.
Let us know.
Let us know how it works out. Okay, Steve, thank you so much. So please do follow up and just drop us a call or pop through an email to let us know what the response was when you went back into the store. And again, you can tell them Wendy Knowler said they should be honouring the price that was displayed on the item on shelf because it was not an obvious mistake. You've used this analogy several times, Wendy, that if a high-tech, very expensive television is accidentally advertised as $50.99 rather than $5,099, you can deem that an obvious mistake that any reasonable consumer would recognize as such.
Exactly.
They have some wiggle room, but this, as you say, is not an obvious.
No, I had a
mistake
case
to
last
spot.
week with 702. A listener had bought a fridge, very fancy brand. I forget, a Libre or something like that. That you often see them on MasterChef Australia.
Yes,
and he bought it it was supposedly marked down, but both prices were wrong. So you could pay 10,000 Rand, and they actually go for 70 something. And he insisted on, they apologized, said, we'll refund you, we'll give you other brands at our cost price or whatever. And he said, no, I want that fridge at that price. And I had to say to him, like, this really is an obvious mistake. And so you're not
being
entitled to
reasonable.
it.
Yeah. Okay. Steve, look forward to hearing the to be continued.
Me too.
Carol writing in to say serves him right for buying Crocs.
Oh,
Carol,
you know what?
be nice. It's World Kindness Day. Be nice and be kind. Okay.
It's actually a brilliant marketing story of how Crocs made their shoes cool again. I read it just this week.
Yeah.
You really just Google. I forget where it appeared. I'm so sorry. As a journalist, I should know the source. But it is the most canny marketing ever. And so people who wear them, and actually, I mean, it's the young people who mostly embrace them now. I'm way out of the target market. And people who value comfortable shoes.
Yes, people who are on their feet. Chefs and nurses.
Exactly. But don't knock it till you tried it is all I can say.
Okay. Let's finish with an open line question that came in from Sally. She would like you to please explain what a parallel product is. She says, I noticed this label on a perfume being sold on one of the major online retailers, and I don't really understand the term.
Yes, I think they should do a better job of explaining that, actually. This is something that the Consumer Protection Act covers. They're also referred to as parallel imports, which are it's a more descriptive term than grey. So they are perfectly authentic, legitimate products. They're not fakes, but they were not meant for this market. So they were manufactured by whatever that perfume brand was or cosmetic brand or whatever, but they were intended for the Middle East market, for example. And so they haven't been brought into this country by the authorized agents for the South African market, which means one main thing, and that is that should you have any problem with the product, those authorized agents don't have to take responsibility for the warranty. Often the big stores that do sell these grey or parallel imports will say, but we will take responsibility for them. We won't turn you away if there's a defect or something.
Okay.
But that's the main difference. And for some people, the price can often be slightly less for whatever reason, and they're willing to take the chance. But the Act does say there has to be full disclosure. And I'm actually thinking of a story here, and that our listeners' question is sort of suggesting to me that people don't actually understand what the term means. So there's one thing disclosing it, but if you're not explaining what it means, are you doing the customers a full service in terms of disclosure?
That's an interesting point, Wendy. Okay, so Sally, thank you for raising it, because I'm sure you weren't the only one who didn't understand the term when you saw it, and appreciate your giving us an opportunity to give it some ventilation.